Today, we are going to talk about earnest money, option fee, and dates in a primary and backup contract. In paragraph 5A of your 1-to-4 family contract, you must insert the escrow agent's name, the address for the escrow agent, and the amount of earnest money and option fee payable to the title company. Paragraph 5A1 of the contract allows for the buyer and seller to negotiate additional earnest money, how much, and when it's due. Earnest money and option fees are due under the contract within 3 days of the effective date. If the last date to deliver earnest money and option fee falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money and option fee is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. If the buyer does not deliver earnest money to the title company within the specified time frame, then the buyer is in default under the contract. Seller may terminate this contract or exercise seller's remedies under paragraph 15, or both, by providing notice to the buyer before the buyer delivers the earnest money. In other words, buyer can cure the default, the failure to deliver the earnest money, by delivering the earnest money to the title company before the seller provides notice to the buyer. The option fee is an amount of money that the buyer pays to the title company that gives the buyer the unrestricted right to terminate the contract by giving notice of termination to the seller within a negotiated amount of days after the effective date of the contract, otherwise known as the option period. If the buyer fails to deliver the option fee within the 3 days, buyer just doesn't have the unrestricted right to terminate the contract. Now, most of you know how earnest money and option fee work, and when they need to be delivered to the title company, and the consequences of not delivering them. Many people, though, still get confused on when the earnest money and option fee are due to the title company under a backup contract and what rights they have under the backup contract. When a buyer's backup contract gets accepted by the seller, the buyer has 3 days from the effective date of the backup contract to deliver the earnest money and option fee to the title company, similar to how the primary contract works. However, in a primary contract, all dates begin running from the effective date of the contract. In a backup contract, only the time periods for the earnest money delivery and option fee delivery run from the effective date of the backup contract. As long as buyer delivers the option fee to the title company within the 3-day time period, buyer has the unrestricted right to terminate the backup contract the entire time that the buyer is in backup position and for the negotiated amount of days specified for the option once the buyer's contract becomes primary, if the original primary contract terminates. When the backup buyer receives notice from the seller that the primary contract terminated, the backup contract becomes primary, and the effective date of the backup contract is now amended to the date that the notice was received by the buyer, and all other time periods start running under the contract. It is imperative that buyers and sellers understand the difference between earnest money and option fee, know the time periods for delivery of each fund, and the consequences for not delivering those funds. Please let us know if you have any questions that we can answer on our Tip of the Week podcast at tipoftheweek@allegiancetitle.com. Thank you. We'll see you at the closing table.